Welcome to today's webinar. I'm Jason Johnson. I'll be your facilitator today. I'm joined today by our subject matter expert, Robert Cosgrove from the law firm of Wade, Clark, McCaughey. During today's presentation, we'll be addressing data breach perils and liabilities, confronting businesses, and offer advice that you can use to help being a victim of this type of crime. At the end of the webinar, we will address your questions in our question and answer segment of the program. To submit a question during the webinar, please type and send it using the chat box feature that you see on your screen. We'll monitor the chat box during the presentation and will address questions at the end of the webinar. After the questions and answers have been compiled, we will publish the webinar and list the questions and answers on our website for your review. Our guest speaker today is Robert Cosgrove, the managing partner of Wade, Clark, McCaughey law firm. Robert handles the defense of products liability, mass tort, intellectual property, fine arts, and Jurors Block. He conducts and defends fraud, data privacy, cybersecurity claims and investigations. He resolves first and third-party insurance coverage disputes and defends errors, omissions, and other professional liability lawsuits. Thank you for joining us, Robert. I will now turn the presentation over to Robert.
Thanks, all the folks at JM, for having me here today. I very much appreciate it, and thank you for the warm welcome. It's my pleasure to be here today and to provide hopefully some guidance for everyone on data breach claims in the U.S. So with that said, let's get started. In the world that we live in the modern world that we're surrounded by data, by information privacy, by cell phones, by iPhones, by Androids, by Googles, there is so much data out there that it just surrounds us all around all the time. And you've seen a lot of articles, a lot of press, a lot of news reports, a lot of everything talking about how data privacy and data security is such a big issue for retailers, such a big issue for customers, such a big issue for everybody who lives in this modern world. And part of the reason that much ado has been made about all of this is because of the reality of a couple of different things. And one of the things that's made a big deal about this is U.S. spying. Obviously, the Patriot Act, the post-9/11 legislation passed in the U.S., and the recent disclosures, in part occasioned by good old Mr. Snowden, indicate that there's a lot of data searches, a lot of cyber searches that are going on and are undertaken by the United States government. And that's caused a lot of consternation by people. Another thing that's sort of given people some pause is a lot of discussions of Chinese cyber attacks. Chinese cyber attacks coming in and trying to access United States Department federal records. Chinese cyber attacks targeting law firms. Chinese cyber attacks targeting major corporations to steal intellectual property, to steal data, to steal things like that. And then, of course, for you guys, you've heard a lot about data breaches of retailers, places like Target or Home Depot or Sony PlayStation, big, sexy data breaches with millions upon millions of consumers affected, and you've heard a lot about those kind of things. And you might say, that's all really, really interesting, but what the heck does any of this have to do with me? I'm a mom-and-pop jewelry store. I'm a small retailer. It's very nice that Target has a problem, that Target has exposure, but what does this mean for me? And the reason all of this matters for you today, and I think what we'll hopefully do today is give you some tools you can use and some things to think about in the future, is at the end of the day, no matter how big or small you are, you could be the subject of a data breach. You could be the subject of a claim being made against you or a lawsuit being filed against you for having released data into the public domain. And you might say, look, I'm a jewelry store. I'm an old-fashioned kind of guy or girl. I just have paper records. I've got my log books, my memo books. That's how I keep track of these things. None of this fancy computer stuff for me. But the fact of the matter is, even if all you have are paper records, if at some point any piece of data in that paper gets transmitted via electronics, via a computer, via an iPhone, via a fax machine, via anything digital, the potential exists that you might have a data breach exposure. And the problem with all of this is you never know what the exposure is until it's simply too late, until the data breach is actually on your door. So what we're going to try to do today, our mission for today, is to go through a couple of different concepts, a couple of different topic areas. First off, we're going to go through key terms. Okay? We're going to tell you what are the key terms you need to know to understand data breach claims so you can talk intelligently about these kinds of things. Secondly, we're going to talk about who is responsible for a data breach. what kind of people bear exposure, both to government agencies and potentially to plaintiffs or class action lawyers who might commence a lawsuit. We're next going to talk about how do they happen. It's great to talk about Chinese cyber attacks and war game movies and things like that, but really how can data breaches affect me as a small retailer? We're next going to talk about the regulatory framework that exists, how you have to respond to the local and federal governmental agencies if you have a data breach. We're going to talk then about lawsuits, the bane of everyone's existence except lawyers, and go through how lawsuits can impact your life in a data breach regime. We're going to talk about the kind of exposure. What kind of money are we talking about if I'm hit with a data breach claim? And then we're going to talk about ways that, on steps that you can take to help protect yourself against these kinds of data breaches. But before going into any of those things, I think the first and the best place to start is to think of all data breach claims as effectively being a three-headed monster of yore. And what I mean by that is all data breach claims have at least three separate and distinct component parts. And the component parts are as follows. First off, you have a governmental and first-party response aspect of a claim, which is you have a data breach. Personally identifiable information gets released out into the public in some unauthorized way. You will have to respond to the government. You will have to respond to regulatory agencies and explain what happened and take steps to deal with the regulations that apply to your particular business. That's the first thing you have to worry about in the data breach arena. The second thing you have to worry about are third-party claims, because we lawyers are very clever and we look for new ways to find money on a regular basis. And the data breach class action regime has become a hotbed of claims that exist and ways that people try to find pockets to pick. So if you have a data breach, there is a potential that you could be the subject of a third-party claim down the road. And we're going to talk about those kinds of lawsuits in a little bit. But probably most importantly for you, if you have a data breach, there's a harm that can exist to your business itself. Your business name is going to be out there in the press, in the papers, in the local newspapers, the television, the radio stations, the web, whatever it might be. And people are going to talk bad about your business. They're going to talk smack about your business. They're going to say, you guys are a bad business company that released my data out into the public. And that can have negative or adverse impacts on your ability to do business. And at the end of the day, the reason you're doing what you do is to make money. And obviously, if this all impacts your business strategies, a data breach, then you're going to have concerns you have to deal with. So now that you've got a sense of how there are three aspects to all these claims, let's talk about what you really need to understand or know. Well, the first key term you need to understand, and this is the building block of all data privacy legislation, language, press releases, etc., is this concept called PII. And PII stands for personally identifiable information. That's what PII is. And what personally identifiable information is it's any data point, any piece of information that allows someone to be identified as an individual as opposed to as a member of a larger class. Now, exactly what type of information allows you to be identified as a particular person is, quite frankly, the subject of a lot of heated negotiation, both in the U.S. Congress, in various state assemblies throughout the United States, and internationally. But typically, personally identifiable information includes such things as an individual's name, their gender, their contact information, their date of birth, their marital status, and spoken languages. Any one of those types of information, if you collect that information, if that information gets disclosed in an authorized way out into the public, that can qualify as the data breach of personally identifiable information. So that's the first key term. The next key term you have to understand is the data collector. This, quite frankly, is the most fundamental concept and the biggest source of exposure for you that you have to understand. A data collector is anyone that collects personally identifiable information. So if you're a jewelry store and you collect the name and date of birth of your customers, their anniversary, where they live, whatever it might be that qualifies as personally identifiable information like we talked about a few slides ago, you are then the data collector. And that has significant implications for your potential exposure, and we'll talk about that in a couple of slides. The next term that's important is data processor. Data processor is an entity that does something with the data that's collected by the data collector. A data processor can be anything from a credit card company, a paycheck company, a web catalog, a marketing provider, a cloud-based server that maintains all your data. Any of those things can become data processors because they have taken the data that you collected and done something with it. That makes them the data processor. And the data processor, while they have exposure for breaches of data, are not as responsible as a data collector. So what are the implications of all of this for you? Well, for you, one of the big sources of exposure you're going to have is you collect, for example, credit card information, right? People buy things in your stores, they buy things online, they do things that result in you receiving personal data like credit card numbers, like bank account numbers, like things of that sort. Once you collect that information, you become the data collector. You are the entity that under the government regulations has the exposure if any party, be it a data processor or some other third party, loses that information. You as the data collector are the one that has responsibility. It also applies to things like employee data. So let's assume you've got 5 or 6 people working for you. You have a self-insured health group to deal with the requirements of the Affordable Care Act or other types of regulations. You have information about dependents, about addresses, all kinds of data you have in a personnel jacket. If that data gets lost by a hospital or by an insurance broker or by some other entity because you collected it, you as the data collector have responsibility for whatever happens next. And those are key points to keep in mind, that once you collect the data, you cannot escape the exposure. The data breach exposure rests exclusively with you as the collector. The next term to understand is, what is a data breach? What does it mean to have a data breach? Well, a data breach, pretty simply defined, is when personally identifiable information has been lost or subject to unauthorized acquisition, access, disclosure, or destruction in a manner that compromises its security, confidentiality, or integrity. So if personally identifiable information gets released out into the public, no matter how big that public might be, you have a data breach on your hands. Now you might say, well, how do I know I've got a data breach? Right? How do I know if this thing is even affecting me? How do I know if I've got personally identifiable information I collected out there in the public? Well, the unfortunate reality is you only know when it happens. Until it happens, you're not going to know that you had a data breach, because typically there's not any warning that someone's going to take steps to try to access your data, or that some employee is going to lose a laptop that has data on it. You won't know until it happens. And that's what makes these things so difficult to deal with. So all you can really do is assess the threats that you have, assess your exposures, and we'll talk about what those exposures are in a couple of slides in order to go forward. So the next, now that you've got a sense of the key terms on this, let's get back to this big question. Who is responsible? And again, and I'm going to beat this horse to death, the data collector is the responsible party. If you collect the data, no matter who lost it, you bear ultimate responsibility for the breach. And this is true even if it's a third party that lost your data. The credit card company has a data breach. The information gets disclosed out in the public. If you are the one that collected the data in the first place, you have the exposure. If your accountant lost data, he lost your payroll records, he lost your your HR records. He lost your logbooks, your memo books, whatever the case might be. If he lost it, he may be the source of a claim that you have, but you are the one that bears the responsibility to the government. And you cannot contract away your liability exposure. And by that, what I mean is, while you eventually might be able to recover back from somebody else damages that you have to pay, you can't simply say, hey, I'm not responsible, I didn't lose the data, my accountant did. Hey, I'm not responsible, I didn't lose the data, the credit card company did. You're still responsible regardless of what contracts or agreements you have in place with somebody else. Okay, so how do data breaches happen? Well, the one that's the sexiest way to think about it is people talk about data breaches occurring from hackers. We think of a Robert Redford type movie or something like that, where hackers under the cover of night are breaking into the mainframes across the United States and stealing this data, stealing the cloud information that's stored on the servers out in Silicon Valley. And that's a very exciting way to think of how data breaches occur. And quite frankly, it can happen that way. If you're a big enough company, if you're Tiffany's, or if you're some major jewelry company with exposure all over the world, it's possible that a hacker might decide to target your company to bring you down. Because, attacking the little blue box is kind of a fun thing to do if you're a hacker. But in the main, if you're a relatively small jeweler, you have the one or two stores in a small town or in a mall or something like that, you're probably not going to be the attack victim of a hacker. Quite frankly, they have bigger targets to go after. You're likely not it. The most common way, therefore, for a data breach to occur is if somebody loses a file. They lose a piece of paper, they lose a computer, they lose anything that has personally identifiable information on it. That's the most common way that data breaches can occur. It's inadvertent, nobody meant to do it, but that doesn't change the scope of exposure. In the data breach regime, the mere fact you didn't mean for it to happen doesn't get you any better result than if you actually meant for something to happen. You're still liable. Employee misconduct is another way it can happen. Let's say you've got an employee who decides they want to set up a rival company. They decide they're going to take your databases and mine them, steal all the information so they can set up a rival jewelry store in the town next door or the town next. That's a source of potential data breaches. And the last one is improper destruction. So you decide you're going from paper files to computer records. You're going to computerize your memo books. You're going to computerize your records. You're going to do all these kinds of things. And here we go. It's all taken care of. And you decide to take all the paper records you had and put them in the garbage pail. Well, that's not such a great way to destroy data because there, any of that information can be taken out of the garbage can, and people can use that data in unauthorized or improper ways. So improper destruction is another way that bad things can happen to you. Now, this might scare the heck out of a lot of you guys, and you might say, oh, what am I supposed to do here? The reality of data breaches are they are almost impossible to prevent. There is very little you can do to make them not happen. And in fact, to some extent, you're up a creek without a paddle. I mean, there is an element to which you cannot control this because people are going to make mistakes. It's possible companies can have their data stolen, credit card companies can be targeted. All these things can happen, and you can't prevent all of these kinds of things. But you still have a business to run. So what can you do? Well, you can do things like encrypt the documents you have that have personally identifiable information on them. If you do that, it's a lot harder for a hacker to find ways to go after that and to get that information. You can also put passwords on the data that you have. So only people with, let's say, double passwords can access the information and get the data. That's a second way you can do things. You can redact information if you, and it's a legal term, but basically to black things out that you don't want people to see, either via a computer in like an Adobe Professional or with a black marker, which was the classic way of doing it. You can redact information, and that will allow you to minimize your risk or reduce your risk. And of course, most importantly, it's important to keep in mind, and I say this as I sit here in Philadelphia today, so I have to quote Ben Franklin as a matter of course, is an ounce of prevention is worth a pound of cure. And the best way you can prevent data breaches is to make sure that you have protection policies in place. The more you do to put procedures in place that minimize the ability of people to have data released onto the public, the better off you're going to be. Think of it this way. So you've got a showcase full of diamonds, watches, rings, etc. You're not going to walk away from the showcase and leave it unsecured or not locked, right? You're going to make sure you lock that up before you take a couple of steps away from that. Well, the same thing has to be the way you think of data privacy claims or data privacy exposure. Let's say you've got a computer at your front desk where the receptionist or the clerk can put in bills, do invoices, write letters, go online, do whatever. Have you taken steps to ensure that that computer screen has a password protection on it, that it locks out and goes into a screensaver password mode after a minute or so? That's a very simple step you can take in the same way you lock up a showcase that allows you to attempt to minimize your risk. So have protection policies in place. And then also importantly, have a response plan in place. So if you get that call in the middle of the night and they say, your data has been compromised, somebody has breached your security protocols, personally identifiable information that you collected is now released onto the public, you know what to do. Because just screaming into the phone is probably not going to get you very far. So have a response plan in place. Know who you have to call so you can begin to deal with the breach if it does occur. Okay, what's the regulatory framework here? That's the next topic area. Well, in the U.S., what makes it kind of complicated is every single state has its own set of regulations. And in the handout materials that you'll be able to download after today's presentation is over, we have put together for you a compendium of roughly, well, about 50 states and what regulations exist in those states. And most of the states in the country have some kind of data breach regulations. Alabama, I think, is the only exception. There's no regulations in Alabama. I'll decline comment on that any further. And in respect of what to do, that gives you some sense of how you have to handle them. And the reason that there's no overarching framework in the U.S., and this has become the big source of problems with other places like the European Union, is because there's no federal agency, believe it or not, in the United States that's empowered to address data breach claims. We have departments of everything, but there's no department of data privacy. There's no department of data breaches. Doesn't exist. The closest agency that exists is the Federal Trade Commission, which has the power to regulate unfair competition and unreasonable trade practices. And so the FTC has been taking steps to regulate and deal with data breach claims. And if you follow the papers, there was a case that's been up on in the papers involving the Wyndham hotel chain, which had a data breach. And the FTC sued Wyndham and said, you guys have a data breach. And the Wyndham responded by saying, well, that's nice that we did, but you, FTC, have nothing to do with it. It's not within your domain of powers or obligations. But the courts thus far, and it's going up to the U.S. Supreme Court, have said that, in fact, the FTC does have that power. So the FTC has some regulations on point. And there are some other kinds of specific regulations that also apply. COPA, HIPAA, FERPA, things like that. The one that's probably the most important for you guys is the CAN spam regulation. Let's assume you have like a weekly email blotter you send out advertising specials or deals or some kind of newsletter you send out. That can make you the target of a CAN spam violation federal action. But otherwise, you're primarily going to be dealing with state regulations. And as I said, all the states have different rules and regulations that apply. And basically, if you have a data breach, any state in which you have a consumer, regardless of where you yourself are located, you may be subject to the regulations of that particular state. In other words, if you're in Maine and you have a data breach and you have one customer in California, you potentially could be the subject of both California privacy regulations and Maine regulations and everything in between the lobsters and the bears. Everything in between could be the subject of regulations you have to respond to. So you could be talking to 50 different attorney generals, 50 different police departments, 50 different, you get the idea. These things get real big real fast, or they say it gets dark real early. And that's what happens here. And that's if you have any kind of web-based retail, you might have exposure like this. It also applies if you let people call into your stores and place an order, and then you ship that to some other spot, regardless of your web-based retail presence. Because once you start shipping things from state to state, and most of you probably do that to some extent, you're going to have exposure in more than one state. And there really isn't any legislation that's currently pending on the federal level to sort of make the whole field a little bit cleaner and a little bit easier to understand. This is a picture I took from a privacy conference in the spring, and these are some congressional staffers who are allegedly working on trying to clarify the issue and deal with consolidating the field of play here. But quite frankly, given where Congress is right now and the issues they have to deal with, I'm not sure this is going to take place anytime in this session at least. So hopefully that's given you some sense of the regulations you have to deal with. Now the next thing you might say is, okay, I've got a data breach, I've dealt with the regulators, life seems good, I can go on with my life. But now it's time for the lawsuits to start rolling in. Because again, lawyers want to make money, they've got to find somebody to sue, and they're going to sue you if you've contributed to or caused a data breach, or if you have the data that was the subject of the breach. You're going to be the target. And we've got in the handout materials that you'll receive an essay that we wrote that goes through some of the, in a very basic way, some of the terms we've talked about today, and also some of the basic kinds of lawsuits that can exist out there. We're going to run through some of those kinds of theories of lawsuits so you have some sense of what to expect. One thing a plaintiff's attorney can say if they're going to sue you is they can say you violated the statute or the rule. Those 50 state regulations we've given you, you did something wrong in respect of one of those regulations, and therefore, boom, you are responsible as the entity, and you violated the statute. And that's negligence per se. They might say you violated the Telephone Consumer Protection Act. You made unsolicited calls. You did something in response that subjected you to exposure. They might say you did a credit check you shouldn't have done. The credit check resulted in the breach, and that's somehow a violation of data privacy rules. But probably most commonly what they're going to say is you were negligent. And negligence is sort of the basic concept in all of law. And it applies to everything like a car accident. You negligently failed to stop at the red light and therefore you rear-ended somebody. To slip and falls, you negligently failed to clear the snow and ice on the sidewalk and therefore somebody slipped and fell when they were walking by. Or data breaches. You negligently failed to secure the data and therefore we have a data breach on our hands where my client's information has been released to the public. And basically what the negligence standard requires in all these arenas is a showing that you, the defendant, did not act like a reasonable person, that you deviated from the reasonable standard of care. And if they can show that, then you might be negligent. Then you might have exposure. And the way that people go about trying to show negligence is, the main way is they show you had inadequate safeguards to protect the data. You didn't have the computer secured with a password. You didn't redact the information. You didn't do all those things we talked about previously. And that was unreasonable under the circumstances. That was inadequate, and therefore you should be held responsible. They also might say you didn't tell me about this. You had a data breach on August 1st, and you didn't tell me until December 1st. And now my data's been out there being used by whomever for whatever nefarious purposes might exist for 5 months. And if you had told me on August 2nd, I would have done things differently. So you'll see a lot of lack of timely notification claims thrown into data breach litigation. They might also say that you breached your contract, that you had some kind of oral or written agreement to implicitly protect their information that they gave to you and that they paid for when they bought the jewelry, and that your failure to maintain the data is a breach of contract. or that's a breach of fiduciary duty. That somehow you should have protected the data, and you had an obligation to make sure you did that. If you have a website presence, they might also say, you put a cookie on my computer. You collected data when you required me to log in with a user ID and password to shop on your website and to give you my credit card information. And that was unsanctioned collection. I didn't know you were going to keep it for all time. It was just for this one transaction. And now you kept it, and now it's out there in the public, and I've got a problem. So unsanctioned collection is another way that people go about these claims. You might also have involuntary disclosure, which is you disclosed it, and I didn't authorize it, and therefore it was involuntary. And that's why there's a data breach. You might have conversion, and this is familiar to all you jewelry folks, the idea that like on a consignment, right, when the claim is that you converted the goods that were consigned to you for your own own purposes, and did not otherwise remit the profits of the conversion back to the consignee. Same kind of thing is true here. They'll say, I gave you my credit card information, and it was converted by you when you gave it to the credit card companies that had the data breach, and I want compensation for the conversion of the information. They might also say you've derived an improper benefit from handling the data, that you had the benefit of collecting money, collecting information, marketing, whatever the case might be, and I haven't gotten any money for that, and therefore you've been improperly benefited. So hopefully that's a crash course. We could do a full hour seminar, and we have, on that topic of lawsuits. But hopefully that gives you some idea of how lawsuits can be structured against you. So what kind of exposure do I have if I've got a data breach, right? Well, what's the story here? What's my exposure? Well, the first exposure you have is in respect of statutory damages, which is to say fines that are going to be implemented against you by a governmental agency, by the state of California, by the Commonwealth of Pennsylvania, by the Federal Trade Commission. And quite frankly, the statutory damages can be considerable. It depends a lot on the state, but you could be looking at $1,000 per individual per breach. That's not an unusual fine. So if you've got a breach of, let's say, the data of 500 customers, that's $1,000 a customer. Well, that's real money, right? I mean, so that's how these things can become big problems for you. The second damage you might face are mitigation expenses, which is somebody might say, hey, because my data was breached, I had to go retain LifeLock or some other company you see advertised on the radio or television or the internet, and I had to pay them $1,000 to go secure my information, secure my identity, to make sure I was not the subject of a privacy violation, of a identity theft. I had to mitigate my exposure. You should pay me back for the money I paid out of pocket. Reimbursement of paid fees. I had to pay for these services. I want to be paid back for that. That's an exposure that you have. Credit monitoring is also a big exposure. And again, credit monitoring is one of those things that for one person is not so much. It's like $15 a month, right? For 12 months a year, not that big a deal if you do it for yourself. But if you take, $120 a year times 500 people, or 1,000 people, or 10,000 people, or 100,000 people, all of a sudden that's a real big number. And it's why, to give you a sense of things, the average case these days, the average data breach claim ends up costing around $400,000 in indemnity payouts, and for things like credit monitoring and reimbursement of paid fees and things like that. It also tends to rack up around $700,000 per claim in legal fees. So you get a sense of how big these claims can be. I think a lot of that's because these claims can be bigger ones, and there are bigger, more expensive law firms that handle the claims. But the fact is they can get really expensive real fast. Identity theft. This is the least likely or the least frequent type of data breach result, when somebody steals somebody else's identity and go buys a car, a yacht, a Ferrari, a new house, some fancy diamonds, whatever the case might be. But if you do have an identity theft, that can get really expensive because of the costs involved in having to to pay somebody back for debts they didn't incur, for damage to their credit that didn't result from their actions, and that can be a real source of exposure for people. So hopefully now I've sufficiently scared you that you are concerned about what might happen if a data breach were to occur, and how you can be exposed to them by pretty much just running your business on a daily basis. So the question is, that you might well have is, what do I do about this? Right? What do I do to protect myself to make sure this doesn't happen to me and I'm not on the front page of the paper or the lead story on the television? Well, one thing you can do is talk to JAM or talk to your insurance companies and ask them if you have insurance coverage for these kinds of things. And JAM, the folks at JAM will tell you what they think in terms of what their policies provide coverage for. There are lots of other companies that are also providing coverage, but JAM, of course, are great folks. And talk to the folks and see what kind of insurance you have. See what kind of experience they can share with you to make sure that you have coverage for the kinds of exposures that you have. Next, naked plug for attorneys, talk to an attorney. Make sure you've developed some kind of response plan so you know how to respond to the requirements in your state or other states where you might do business. So you have a list of phone numbers of who to call now that the breach has occurred, that you have something you can do so when that phone call happens or the phone call comes in, you're not going to just scream, you're going to actually do something. You're going to say, okay, now we're going to go to step one, which is to do this. Bring in an IT consultant, bring in this. So talk to an attorney or a specialist who can help you design a program to respond to data breaches. Implement a crisis plan. Have something in place that allows you, after talking to JM, talking to an attorney, talking to crisis managers, have a plan in place that you can use, that you can implement if and when a data breach occurs. Make sure you can do something because that's probably the best advice and the best defense you have is to be prepared to go on the offensive if you find out that the worst thing possible for your business perspective has happened. So, with all of that said, what is the takeaway? What should you have learned, I hope, from today's lesson? Well, first off, I hope you've gotten a sense of what some of the key terms are. Things like PII, personally identifiable information. I hope you've learned about data collectors, which basically means you, if you collect data, if you collect personally identifiable information. You've learned about data processors, the vendors you use, your accountants, your healthcare providers, your brokers, your credit card companies that are data processors that do something with information that you collect. You've learned about what a data breach itself is. And if you have a sense of those basic sets of terms, you're far better off than most of the public, and you're far better prepared to deal with something if it does happen. Next, hopefully you've gotten a sense of who is responsible. And ultimately here, the buck stops with you. If you collect the data, you become the party that's responsible for the data breach. You become the party that has the exposure to the government and to the plaintiff's lawyers. You might find ways you can minimize that risk via insurance, via contracts, via whatever, but you will be the person with whom the buck stops. And that, is a significant responsibility that requires significant responses. How does it happen? Well, hopefully you've gotten a sense of that. Most common way, somebody loses something. They lose an iPhone. They lose an iPad. I have a partner who's always losing his iPad, which is a big source of our internal meetings. I won't tell you who he is, but he tends to have that problem. Laptops, all kinds of things like that. Those kind of loss of data, those kind of loss of information like that, a misplaced file on a car roof, they can be the most common source of a data breach. Then you have hackers, you have employee misconduct, you have things like that. But there are a couple of different ways this can happen. The regulatory framework is a minefield, and the minefield is that every state's got its own regulations. Every state has got its own set of rules and practices that apply, and you've got to be prepared to respond to any state's regulations in which you have consumers if a data breach occurs. So you have to have some sense of, do I have 50 customers in California? Do I have 5,000 customers in California? A lot of these regulations are specific to the number of consumers affected by the breach. And if there aren't enough consumers for only one person, then you don't really have to worry about it. But if there's 500 or 1,000 or 2,000, you might have to worry about it. Hopefully it's given you some idea of what to expect if you are sued in one of these instances. And really it comes down to this idea of negligence and doing something that's not reasonable under the circumstances. So the key for you gets back to that whole ounce of prevention being worth 2 of cure, or a pound of cure. If you can find a way to put protocols and procedures in place ahead of time, if they allow you to show that you're acting reasonably and consistent with the best practices that are out there, it would be a lot harder for somebody to say that you were unreasonable and that's where the data breach occurred. Because just because something happened doesn't mean that somebody is liable as a matter of law. It's forgotten all the time in all kinds of different lawsuits, but it's also true here. In terms of exposure, you're looking at statutory fines, you're looking at damages, you're looking at credit monitoring, you're looking at the mitigation costs, a whole bunch of different kinds of exposure that can exist in a case like this. In terms of what you can do, hopefully you recognize you need to talk to people, whether it's a lawyer, whether it's an insurance company, whether it's a crisis management consultant, and have a plan in place so that if this happens, you're not trying to scramble after the fact to deal with it. Rather, you have something in place that allows you to respond in an aggressive manner and make sure you're doing the right thing to minimize the potential costs in the long term to you. When all is said and done, though, we are standing at the dawn of a new era. I mean, if you think about it, go back to 2002, 2004. There were no iPhones, right? You had dial-up internet, if you had that. Maybe you had an email address you used. Maybe you had AOL, right? You had all those kinds of things that were just sort of in their infancy. And now we're in a world where everybody has a smartphone, or almost everybody has a smartphone. We're in a world where most people have some kind of fancy internet service, at least who are in business. And there's data everywhere. People post things on Facebook I would never think of sharing with anybody, even my best friends. And we're at the dawn of a new era, and I think this exposure is only going to increase as we continue to put more and more things out there into the public domain. So because it's all new, there's an element of this to which we're making up the rules and the ways in which we have to respond to data breaches as we go forward. It is all new. It is all novel. So all you can do is act as reasonably as possible, and that's the best defense you can have. Because at the end of the day, you have to keep in mind, no matter what you do, you're going to have exposure. And the reason for that is pretty simple. In the world that we live in, as Rockwell put it so illustriously way back in the early 1980s, before any of this was in anybody's mind, in the world that we live in, somebody is always watching you. And that's an exposure and a risk that you have to be prepared to deal with. So with that said, thank you all very much for your time today. I appreciate you listening. Hopefully we've given you a sense of the issues in this case, or in the issues in this subject matter or topic area. I think we can turn it now to questions.
Thank you. We've been collecting your questions and are ready to answer them at this time. If you have a question you have not yet submitted, please remember to submit it using the chat box feature. We'll continue to monitor the chat box and we'll answer questions as possible. For those questions we are unable to answer, we will compile them in a frequently asked questions document and we'll post it along with the recording of this webinar on our website. Matt Teese with Jewelers Mutual Staff Underwriting Department and Robert Cosgrove will be assisting you with our question and answer segment. Robert, I see we have a couple questions here. Could you take a few to answer at this time?
Sure. Yeah, no problem. One of the questions we have here is, does allowing a retail customer to swipe their card on the retailer's credit card machine equal data collection? The answer is yes, it does. Anytime, because you're the one in possession, you own the credit card machine, right? You're leasing it. It's your machine. You are collecting that data for purposes of the transaction. So I think it's fair to say you have exposure in that regard for collecting the data in that way, because the machine is in your store. And unfortunately, you can't go back to a cash-only basis. No one has that kind of cash in their pocket anymore, so you're kind of stuck with the credit cards. So hopefully that answers that question. Another question is there any problem with collecting customer email through a lucky draw style competition, using this data for future email marketing to these people? Interesting question. The answer is it kind of depends on, first off, whether you're in the United States or in some other place as well, because the rules differ dramatically if you're, let's say, in Canada or, more importantly, in Europe, as opposed to the U.S. But assuming we're only dealing with the U.S. Regime, there's no problem with that as long as customers understand that they're being entered for a drawing and a chance to win something. It's when you collect the cards and don't tell them that it's going to be used for something that the regulators can get excited, especially regulators in Europe, where there are all kinds of different rights that apply, right to be forgotten, things like that are problematic. But there's nothing wrong with it. You're okay doing that. Next question is, with encrypted card swipes, our system does not record card numbers. Are we responsible for credit card numbers? Interesting question. The answer is yes, you're responsible, but your exposure is going to be minimized. And the reason is because the systems you have as the collector are ones that are reasonable under the circumstances. You are the ones that encrypted it. You followed the best protocols. You encrypted data. And by doing that, you minimize the ability of anybody to say you did something wrong. And if all that you have is the ability to take encrypted information without having to take any special information about the customer, then you're in a better position than most in respect of minimizing your exposure to these kinds of claims. It's why there's been all the discussion of Apple Pay and some of the other systems that are out there, and who's got the data, how does the data work, is it encrypted, is it not encrypted? That's why this has been such a big issue. Everybody's still working through it and the implications of it, but generally the more you only have access to encrypted data, the less exposure you have and the more exposure rests on the back end. And typically because the encrypted credit cards come in and the matching up of the credit card with a particular person occurs somewhere else. So that collection, that matching of a one-to-one basis is not your collection of data, it's somebody else's, and that's why this is a good way to minimize your risk. An employee leaves and takes all your customer notes to a new store. They don't have permission. How do we best protect everyone once this happens? Ooh, that's a complicated one, because if you start writing letters to all your customers saying, "Hey, we have rogue employees that who didn't like us and they left us, they took all your data with you," that's some pretty bad business PR for you guys. So I don't really think that's necessarily in your best interest. The question is going to really depend on what kind of data, what kind of customer notes, what kind of customer records were taken to the new store. Probably if the person is going to open up their own store, your best bet is probably to send a cease and desist letter via lawyers to the other side. And if it's another store that hired somebody, you can probably do the same kind of thing. But typically your best response in that situation is to deal with the entity to which the data was taken, as opposed to telling your customers, at least at the first response. Most states do not require you to notify customers of a potential data breach unless certain conditions are met. And the mere theft of data is more of a trade secret, unfair competition legal claim than is a data breach claim. So I think your best bet would be to have your local lawyer draft a letter for you that says, "Give us back this information or we're going to sue you." And typically that puts the fear of God in most people, because most people hate and fear lawyers, and you're in a much better position. Okay, if customers don't have a card with a chip, are you responsible? Yes. The fact that they use a card that doesn't have one of the new security chips in it doesn't impact or protect you from having exposure if the information gets stolen, hijacked, misplaced, lost, whatever, by some other party. You can still have responsibility for the breach because you collected the data. You accepted the money in exchange for selling the jewelry, the ring, the earring, the watch, whatever the case might be. So you will have exposure. Next question is, I think, one more for Matt and JM. There's a question of whether or not some of this coverage we put into the JM policies automatically. That's an underwriting question that I'll duck on, and I'll leave that one to you guys as to what JM's thinking in that regard. Matt, you want to answer that one?
Thanks, Robert. Yeah, currently our policy excludes that, but we do have via an endorsement where we can add that on, and we have been offering that with all of our proposals as an option, so people are aware that they can purchase that coverage for themselves.
The chip is supposed to eliminate the problem, somebody has pointed out, and that is true. The chip is supposed to protect that by making sure that the consumer or the retail store does not have access to personally identifiable information, which in turn then would minimize the exposure for the store, or eliminate the exposure for the store. But here's the important point to keep in mind here, is just because you have these cards with the chips, you have the credit card companies accepting responsibility for it, unless the regulations that exist change to say, if you only accept cards with chips, you have no exposure. Or unless courts consistently say, if a lawsuit occurs, that a card with a chip is the gold standard of data protection, and therefore we don't think there's no cause of action against someone who allows customers to use cards with chips to collect monies to pay for services. Unless that happens, that's not going to prevent anybody from suing you or from making a claim against you, even if you have a card with chip. That's what you use. Okay. Question was, we have a brochure or printout regarding the data breach in cyber you can share with other coworker. The answer is yes, we do. It's the handout materials that you'll be able to download or be sent to you, I'm not sure how, after today's presentation is over. That does have, as part of it, it's got some case law, which if you're really so inclined, you can read the case law and read all things that we lawyers read. But there are two simpler things to look at, and that's what I'd recommend you start with. One of which is an essay that talks about some of the key terms, I think in a rather easy to follow manner, at least I hope it's easy to follow, and talks about lawsuits and some of the issues in lawsuits. And then there's also the chart that lays out the regulations in a general sense in all 50 states. And how the particular regulations apply to your particular case and your particular breach, it's going to vary, but at least you have some sense of what's out there. And that was our hope in putting that together for you.
Hey, Robert. Jewelers Mutual also has some brochures that spell out some of the coverages that we can offer, and we will include that with the material on the website as well.
Okay, before we wrap up today's webinar, on behalf of Jewelers Mutual staff, Robert Cosgrove from Wade Clark McCullough Law Firm, myself, we want to thank you for participating in today's session. For our policyholders, we thank you for your business and your faith you place in us to help protect you, your staff, your clients, and your business. We trust you found the information shared today to be helpful and may register for future webinars. If you think of a question or have any suggestions, please contact your agent, the Jewelers Mutual Staff Underwriting Department, or our Loss Prevention Department at 1-800-558-6411. In closing, please remember that a recording of this webinar will be posted on our website in the near future. Thank you again, and this concludes the webinar. Thank you.